This video contains the full text of Rules 92 to 109 of the Rules on Special Proceedings. General Guardians and Guardianship. Rule 92. Venue. Section 1. Where to institute proceedings. Guardianship of the person, or estate of a minor or incompetent, may be instituted in the Court of First Instance of the province, or in the Justice of the Peace Court of the municipality, or in the Municipal Court of the chartered city, where the minor or incompetent person resides, and if he resides in a foreign country, in the Court of First Instance of the province wherein his property or part thereof is situated. Provided, however, that where the value of the property of such minor or incompetent, exceeds the jurisdiction of the Justice of the Peace or Municipal Court, the proceedings shall be instituted in the Court of First Instance. In the City of Manila, the proceedings shall be instituted in the Juvenile and Domestic Relations Court. Section 2. Meaning of word, incompetent. Under this rule, the word incompetent includes persons suffering the penalty of civil interdiction, or who are hospitalized lepers, prodigals, deaf and dumb who are unable to read and write, those who are of unsound mind, even though they have lucid intervals, and persons not being of unsound mind, but by reason of age, disease, weak mind, and other similar causes, cannot, without outside aid, take care of themselves and manage their property, becoming thereby an easy prey for deceit and exploitation. Section 3. Transfer of venue. The court taking cognizance of a guardianship proceeding, may transfer the same to the court of another province or municipality, wherein the ward has acquired real property, if he has transferred thereto his bona fide residence, and the latter court shall have full jurisdiction to continue the proceedings, without requiring payment of additional court fees. Rule 93. Appointment of guardians. Section 1. Who may petition for appointment of guardian for resident? Any relative, friend, or other person on behalf of a resident minor or incompetent, who has no parent or lawful guardian, or the minor himself, if 14 years of age or over, may petition the court having jurisdiction, for the appointment of a general guardian, for the person or estate, or both, of such minor or incompetent. An officer of the Federal Administration of the United States in the Philippines, may also file a petition in favor of a ward thereof, and the Director of Health, in favor of an insane person who should be hospitalized, or in favor of an isolated leper. Section 2. Contents of petition. A petition for the appointment of a general guardian must show, so far as known to the petitioner, a. The jurisdictional facts. b. The minority or incompetency, rendering the appointment necessary or convenient. c. The names, ages, and residences of the relatives of the minor or incompetent, and of the persons having him in their care. d. The probable value and character of his estate. e. The name of the person, for whom letters of guardianship are prayed. The petition shall be verified, but no defect in the petition or verification, shall render void the issuance of letters of guardianship. Section 3. Court to set time for hearing, notice thereof. When a petition for the appointment of a general guardian is filed, the court shall fix a time and place for hearing the same, and shall cause reasonable notice thereof, to be given to the persons mentioned in the petition residing in the province, including the minor, if above 14 years of age, or the incompetent himself, and may direct other general or special notice thereof to be given. Section 4. Opposition to petition. Any interested person may, by filing a written opposition, contest the petition on the ground of majority of the alleged minor, competency of the alleged incompetent, or the unsuitability of the person for whom letters are prayed, and may pray that the petition be dismissed, or that letters of guardianship issue to himself, or to any suitable person named in the opposition. Section 5. Hearing and order for letters to issue. At the hearing of the petition, the alleged incompetent must be present, if able to attend, and it must be shown that the required notice has been given. Thereupon, the court shall hear the evidence of the parties in support of their respective allegations, and, if the person in question is a minor, or incompetent, it shall appoint a suitable guardian of his person or estate, or both, with the powers and duties hereinafter specified. Section 6. When and how guardian for non-resident appointed, notice. When a person liable to be put under guardianship, resides without the Philippines but has estate therein, any relative or friend of such person, or anyone interested in his estate, in expectancy or otherwise, may petition a court having jurisdiction, for the appointment of a guardian for the estate, and if, after notice given to such person, and in such manner as the court deems proper, by publication or otherwise, and hearing, the court is satisfied that such non-resident is a minor or incompetent, rendering a guardian necessary or convenient, it may appoint a guardian for such estate. Section 7. Parents as guardians. When the property of the child under parental authority, is worth 2,000 pesos or less, the father or the mother, without the necessity of court appointment, shall be his legal guardian. When the property of the child is worth more than 2,000 pesos, the father or the mother shall be considered guardian of the child's property, with the duties and obligations of guardians under these rules, and shall file the petition required by Section 2 thereof. For good reasons the court may, however, appoint another suitable person. Section 8. Service of judgment. Final orders or judgments under this rule, shall be served upon the civil registrar of the municipality or city where the minor or incompetent person resides, or where his property or part thereof, is situated. Rule 94. Bonds of guardians. Section 1. Bond to be given before issuance of letters, amount, conditions. Before a guardian appointed enters upon the execution of his trust, or letters of guardianship issue, he shall give a bond, in such sum as the court directs, conditioned as follows. A. To make and return to the court, within 3 months, a true and complete inventory of all the estate, real and personal, of his ward which shall come to his possession or knowledge, or to the possession or knowledge of any other person for him. B. To faithfully execute the duties of his trust, to manage and dispose of the estate according to these rules for the best interest of the ward, and to provide for the proper care, custody, and education of the ward. C. To render a true and just account of all the estate of the ward in his hands, and of all proceeds or interest derived therefrom, and of the management and disposition of the same, at the time designated by these rules, and such other times as the court directs, and at the expiration of his trust, to settle his accounts with the court, and deliver and pay over all the estate, effects, and monies remaining in his hands, or due from him on such settlement, to the person lawfully entitled thereto. D. To perform all orders of the court by him to be performed. Section 2. When new bond may be required and old sureties discharged. Whenever it is deemed necessary, the court may require a new bond to be given by the guardian, and may discharge the sureties on the old bond from further liability, after due notice to interested persons, when no injury can result therefrom to those interested in the estate. Section 3. Bonds to be filed, actions thereon. Every bond given by a guardian, shall be filed in the office of the clerk of the court, and, in case of the breach of a condition thereof, may be prosecuted in the same proceeding, or in a separate action, for the use and benefit of the ward, or of any other person legally interested in the estate. Rule 95. Selling and encumbering property of ward. Section 1. Petition of guardian for leave to sell or encumber estate. When the income of an estate under guardianship, is insufficient to maintain the ward and his family, or to maintain and educate the ward when a minor, or when it appears that it is for the benefit of the ward, that his real estate or some part thereof be sold, or mortgaged or otherwise encumbered, and the proceeds thereof put out at interest, or invested in some productive security, or in the improvement or security of other real estate of the ward, the guardian may present a verified petition to the court by which he was appointed, setting forth such facts, and praying that an order issue authorizing the sale or encumbrance. Section 2. Order to show cause thereupon. If it seems probable, that such sale or encumbrance is necessary, or would be beneficial to the ward, the court shall make an order, directing the next of kin of the ward, and all persons interested in the estate, to appear at a reasonable time and place therein specified, to show cause why the prayer of the petition should not be granted. Section 3. Hearing on return of order, costs. At the time and place designated in the order to show cause, the court shall hear the proofs and allegations of the petitioner and next of kin, and other persons interested, together with their witnesses, and grant or refuse the prayer of the petition as the best interest of the ward require. The court shall make such order as to cost of the hearing as may be just. Section 4. Contents of order for sale or encumbrance, and how long effective, bond. If, after full examination, it appears that it is necessary, or would be beneficial to the ward, to sell or encumber the estate, or some portion of it, the court shall order such sale or encumbrance, and that the proceeds thereof be expended for the maintenance of the ward and his family, or the education of the ward, if a minor, or for the putting of the same out at interest, or the investment of the same as the circumstances may require. The order shall specify the causes why the sale or encumbrance is necessary or beneficial, and may direct that estate ordered sold be disposed of, at either public or private sale, subject to such conditions as to the time and manner of payment, and security where a part of the payment is deferred, as in the discretion of the court, are deemed most beneficial to the ward. The original bond of the guardian, shall stand as security for the proper appropriation of the proceeds of the sale, but the judge may, if deemed expedient, require an additional bond, as a condition for the granting of the order of sale. No order of sale granted in pursuance of this section, shall continue in force more than 1 year after granting the same, without a sale being had. Section 5. Court may order investment of proceeds and direct management of estate. The court may authorize and require the guardian, to invest the proceeds of sales or encumbrances, and any other of his ward's money in his hands, in real estate or otherwise, as shall be for the best interest of all concerned, and may make such other orders, for the management, investment, and disposition of the estate and effects, as circumstances may require. Rule 96. General powers and duties of guardians. Section 1. To what guardianship shall extend. A guardian appointed, shall have the care and custody of the person of his ward, and the management of his estate, or the management of the estate only, as the case may be. The guardian of the estate of a non-resident, shall have the management of all the estate of the ward within the Philippines, and no court other than that in which such guardian was appointed, shall have jurisdiction over the guardianship. Section 2. Guardian to pay debts of ward. Every guardian must pay the ward's just debts out of his personal estate and the income of his real estate, if sufficient; if not, then out of his real estate upon obtaining an order for the sale or encumbrance thereof. Section 3. Guardian to settle accounts, collect debts, and appear in actions for ward. A guardian must settle all accounts of his ward, and demand, sue for, and receive all debts due him, or may, with the approval of the court, compound for the same and give discharges to the debtor, on receiving a fair and just dividend of the estate and effects, and he shall appear for, and represent his ward in all actions and special proceedings, unless another person be appointed for that purpose. Section 4. estate to be managed frugally, and proceeds applied to maintenance of ward. A guardian must manage the estate of his ward, frugally and without waste, and apply the income and profits thereof, so far as may be necessary, to the comfortable and suitable maintenance of the ward and his family, if there be any, and if such income and profits be insufficient for that purpose, the guardian may sell or encumber the real estate, upon being authorized by order so to do, and apply so much of the proceeds as may be necessary to such maintenance. Section 5. Guardian may be authorized to join in partition proceedings after hearing. The court may authorize the guardian to join in an assent to a partition of real or personal estate, held by the ward jointly or in common with others, but such authority shall only be granted after hearing, upon such notice to relatives of the ward as the court may direct, and a careful investigation as to the necessity and propriety of the proposed action. Section 6. Proceedings when person suspected of embezzling or concealing property of ward. Upon complaint of the guardian or ward, or of any person having actual or prospective interest in the estate of the ward as creditor, heir, or otherwise, that anyone is suspected of having embezzled, concealed, or conveyed away any money, goods, or interest, or a written instrument, belonging to the ward or his estate, the court may cite the suspected person, to appear for examination touching such money, goods, interest, or instrument, and make such orders as will secure the estate against such embezzlement, concealment or conveyance. Section 7. Inventories and accounts of guardians, and appraisement of estates. A guardian must render to the court an inventory of the estate of his ward, within 3 months after his appointment, and annually after such appointment an inventory and account, the rendition of any of which may be compelled upon the application of an interested person. Such inventories and accounts shall be sworn to by the guardian. All the estate of the ward described in the first inventory shall be appraised. In the appraisement, the court may request the assistance of one or more of the inheritance tax appraisers. And whenever any property of the ward not included in an inventory already rendered is discovered, or succeeded to, or acquired by the ward, like proceedings, shall be had for securing an inventory and appraisement thereof, within 3 months after such discovery, succession, or acquisition. Section 8. When guardian's accounts presented for settlement. Expenses and compensation allowed. Upon the expiration of a year from the time of his appointment, and as often thereafter as may be required, a guardian must present his account to the court for settlement and allowance. In the settlement of the account, the guardian, other than a parent, shall be allowed the amount of his reasonable expenses incurred in the execution of his trust, and also such compensation for his services as the court deems just, not exceeding 15% of the net income of the ward. Rule 97. Termination of guardianship. Section 1. Petition that competency of ward be adjudged, and proceedings thereupon. A person who has been declared incompetent for any reason, or his guardian, relative, or friend, may petition the court to have his present competency judicially determined. The petition shall be verified by oath, and shall state that such person is then competent. Upon receiving the petition, the court shall fix a time for hearing the questions raised thereby, and cause reasonable notice thereof to be given to the guardian of the person, so declared incompetent, and to the ward. On the trial, the guardian or relatives of the ward, and, in the discretion of the court, any other person, may contest the right to the relief demanded, and witnesses may be called, and examined by the parties or by the court on its own motion. If it be found that the person is no longer incompetent, his competency shall be adjudged, and the guardianship shall cease. Section 2. When guardian removed or allowed to resign, new appointment. When a guardian becomes insane, or otherwise incapable of discharging his trust, or unsuitable therefor, or has wasted or mismanaged the estate, failed for 30 days after it is due to render an account or make a return, the court may, upon reasonable notice to the guardian, remove him, and compel him to surrender the estate of the ward, to the person found to be lawfully entitled thereto. A guardian may resign, when it appears proper to allow the same, and upon his resignation or removal, the court may appoint another in his place. Section 3. Other termination of guardianship. The marriage or voluntary emancipation of a minor ward, terminates the guardianship of the person of the ward, and shall enable the minor to administer his property as though he were of age, but he cannot borrow money, or alienate or encumber real property, without the consent of his father or mother, or guardian. He can sue and be sued in court, only with the assistance of his father, mother or guardian. The guardian of any person, may be discharged by the court when it appears, upon the application of the ward or otherwise, that the guardianship is no longer necessary. Section 4. Record to be kept by the Justice of the Peace or Municipal Judge. When a Justice of the Peace or Municipal Court, takes cognizance of the proceedings in pursuance of the provisions of these rules, the record of the proceedings, shall be kept as in the court of first instance. Section 5. Service of Judgment. Final orders or judgments under this rule, shall be served upon the civil registrar of the municipality or city, where the minor or incompetent person resides, or where his property or part thereof is situated. Rule 98. Trustees. Section 1. Where trustee appointed. A trustee necessary to carry into effect the provisions of a will or written instrument, shall be appointed by the court of first instance in which the will was allowed, if it be a will allowed in the Philippines, otherwise by the court of first instance of the province in which the property, or some portion thereof, affected by the trust is situated. Section 2. Appointment and powers of trustee under will. Executor of former trustee need not administer trust. If a testator has omitted in his will to appoint a trustee in the Philippines, and if such appointment is necessary to carry into effect the provisions of the will, the proper court of first instance may, after notice to all persons interested, appoint a trustee, who shall have the same rights, powers, and duties, and in whom the estate shall vest, as if he had been appointed by the testator. No person succeeding to a trust as executor or administrator of a former trustee, shall be required to accept such trust. Section 3. Appointment and powers of new trustee under written instrument. When a trustee, under a written instrument, declines, resigns, dies, or is removed before the objects of the trust are accomplished, and no adequate provision is made in such instrument for supplying the vacancy, the proper court of first instance may, after due notice to all persons interested, appoint a new trustee to act alone or jointly with the others, as the case may be. Such new trustee, shall have and exercise the same powers, rights, and duties, as if he had been originally appointed, and the trust estate, shall vest in him in like manner as it had vested or would have vested, in the trustee in whose place he is substituted, and the court may order such conveyance to be made, by the former trustee or his representatives, or by the other remaining trustees, as may be necessary or proper to vest the trust estate in the new trustee, either alone or jointly with the others. Section 4. Proceedings where trustee appointed abroad. When land in the Philippines is held in trust for persons resident here, by a trustee who derives his authority from without the Philippines, such trustee shall, on petition filed in the court of first instance of province where the land is situated, and after due notice to all persons interested, be ordered to apply to the court for appointment as trustee, and upon his neglect or refusal to comply with such order, the court shall declare such trust vacant, and shall appoint a new trustee, in whom the trust estate shall vest. In like manner, as if he had been originally appointed by such court. Section 5. Trustee must file bond. Before entering on the duties of his trust, a trustee shall file with the clerk of the court having jurisdiction of the trust, a bond in the amount fixed by the judge of said court, payable to the government of the Philippines, and sufficient and available for the protection of any party in interest, and a trustee who neglects to file such bond, shall be considered to have declined or resigned the trust. But the court may, until further order, exempt a trustee under a will from giving a bond, when the testator has directed or requested such exemption, and may so exempt any trustee, when all persons beneficially interested in the trust, being of full age, request the exemption. Such exemption may be cancelled by the court at any time, and the trustee required to forthwith file a bond. Section 6. Conditions included in bond. The following conditions shall be deemed to be a part of the bond whether written therein or not. A. That the trustee will make and return to the court, at such time as it may order, a true inventory of all the real and personal estate belonging to him as trustee, which at the time of the making of such inventory, shall have come to his possession or knowledge. B. That he will manage and dispose of all such estate, and faithfully discharge his trust in relation thereto, according to law, and the will of the testator, or the provisions of the instrument or order under which he is appointed. C. That he will render upon oath, at least once a year until his trust is fulfilled, unless he is excused therefrom in any year by the court, a true account of the property in his hands, and of the management and disposition thereof, and will render such other accounts as the court may order. D. That at the expiration of his trust, he will settle his accounts in court, and pay over and deliver all the estate remaining in his hands, or due from him on such settlement, to the person or persons entitled thereto. But when the trustee is appointed as a successor to a prior trustee, the court may dispense with the making and return of an inventory, if one has already been filed, and in such case, the condition of the bond shall be deemed to be altered accordingly. Section 7. Appraisal, compensation of trustee. When an inventory is required to be returned by a trustee, the estate and effects belonging to the trust, shall be appraised, and the court may order one or more inheritance tax appraisers to assist in the appraisement. The compensation of the trustee, shall be fixed by the court, if it be not determined in the instrument creating the trust. Section 8. Removal or resignation of trustee. The proper court of first instance may, upon petition of the parties beneficially interested, and after due notice to the trustee and hearing, remove a trustee, if such removal appears essential in the interests of the petitioners. The court may also, after due notice to all persons interested, remove a trustee who is insane, or otherwise incapable of discharging his trust, or evidently unsuitable therefor. A trustee, whether appointed by the court or under a written instrument, may resign his trust, if it appears to the court proper to allow such resignation. Section 9. Proceedings for sale or encumbrance of trust estate. When the sale or encumbrance of any real or personal estate held in trust, is necessary or expedient, the court having jurisdiction of the trust may, on petition and after due notice and hearing, order such sale or encumbrance to be made, and the reinvestment and application of the proceeds thereof, in such manner as will best affect the objects of the trust. The petition, notice, hearing, order of sale or encumbrance, and record of proceedings, shall conform, as nearly as may be to the provisions concerning the sale or encumbrance by guardians of the property of minors or other wards. Rule 99. Adoption and custody of minors. Section 1. Venue. A person desiring to adopt another, or have the custody of a minor, shall present his petition to the court of first instance of the province, or the municipal or justice of the peace court of the city or municipality in which he resides. In the city of Manila, the proceedings shall be instituted in the Juvenile and Domestic Relations Court. Section 2. Contents of petition. The petition for adoption, shall contain the same allegations required in a petition for guardianship, to wit: A. The jurisdictional facts. B. The qualifications of the adopter. C. That the adopter is not disqualified by law. D. The name, age, and residence of the person to be adopted, and of his relatives, or of the persons who have him under their care. E. the probable value and character of the estate of a person to be adopted. Section 3. Consent to adoption. There shall be filed with the petition, a written consent to the adoption, signed by the child, if 14 years of age or over, and not incompetent, and by the child's spouse, if any, and by each of its known living parents, who is not insane, or hopelessly intemperate, or has not abandoned such child, or if there are no such parents, by the general guardian or guardian ad litem of the child, or if the child is in the custody of an orphan asylum, children's home, or benevolent society or person, by the proper officer or officers of such asylum, home, or society, or by such person. But if the child is illegitimate, and has not been recognized, the consent of its father to the adoption, shall not be required. If the person to be adopted is of age, only his or her consent and that of the spouse, if any, shall be required. Section 4. Order for hearing. If the petition and consent filed, are sufficient in form and substance, the court, by an order reciting the purpose of the petition, shall fix a date and place for the hearing thereof, which date shall not be more than 6 months after the entry of the order, and shall direct, that a copy of the order be published before the hearing, at least once a week for 3 successive weeks, in some newspaper of general circulation published in the province, as the court shall deem best. Section 5. Hearing and Judgment. Upon satisfactory proof in open court, on the date fixed in the order, that such order has been published as directed, that the allegations of the petition are true, and that it is a proper case for adoption, and the petitioner or petitioners are able to bring up and educate the child properly, the court shall adjudge that, thenceforth the child is freed from all legal obligations of obedience and maintenance with respect to its natural parents, except the mother, when the child is adopted by her husband, and is, to all legal intents and purposes, the child of the petitioner or petitioners, and that its surname is changed to that of the petitioner or petitioners. The adopted person or child, shall thereupon become the legal heir of his parents by adoption, and shall also remain the legal heir of his natural parents. In case of the death of the adopted person or child, his parents and relatives by nature, and not by adoption, shall be his legal heirs. Section 6. Proceedings as to child whose parents are separated, appeal. When husband and wife are divorced, or living separately and apart from each other, and the question as to the care, custody, and control of a child or children of their marriage, is brought before a court of first instance by petition, or as an incident to any other proceeding, the court, upon hearing the testimony as may be pertinent, shall award the care, custody, and control of each such child, as will be for its best interest, permitting the child to choose which parent it prefers to live with, if it be over 10 years of age, unless the parent so chosen, be unfit to take charge of the child, by reason of moral depravity, habitual drunkenness, incapacity, or poverty. If, upon such hearing, it appears that both parents, are improper persons to have the care, custody, and control of the child, the court may either designate the paternal or maternal grandparent of the child, or his oldest brother or sister, or some reputable and discreet person to take charge of such child, or commit it to any suitable asylum, children's home, or benevolent society. The court may, in conformity with the provisions of the Civil Code, order either or both parents to support, or help support said child, irrespective of who may be its custodian, and may make any order that is just and reasonable, permitting the parent who is deprived of its care and custody to visit the child, or have temporary custody thereof. Either parent may appeal from an order, made in accordance with the provisions of this section. No child under 7 years of age, shall be separated from its mother, unless the court finds there are compelling reasons therefor. Section 7. Proceedings as to vagrant or abused child. When the parents of any minor child, are dead, or by reason of long absence, or legal or physical disability, have abandoned it, or cannot support it through vagrancy, negligence, or misconduct, or neglect or refuse to support it, or treat it with excessive harshness, or give it corrupting orders, counsels, or examples, or cause or allow it to engage in begging, or to commit offenses against the law, the proper court of first instance. Upon petition filed by some reputable resident of the province setting forth the facts, may issue an order, requiring such parents to show cause, or, if the parents are dead or cannot be found, requiring the fiscal of the province to show cause, at a time and place fixed in the order, why the child should not be taken from its parents, if living, and if upon the hearing it appears that the allegations of the petition are true, and that it is for the best interest of the child, the court may make an order taking it from its parents, if living, and committing it to any suitable orphan asylum, children's home, or benevolent society or person, to be ultimately placed, by adoption or otherwise, in a home found for it by such asylum, children's home, society or person. Section 8. Service of Judgment. Final orders or judgments under this rule, shall be served by the clerk upon the civil registrar of the city or municipality, wherein the court issuing the same is situated. Rule 100. Rescission and Revocation of Adoption. Section 1. Who may file petition, grounds. A minor or other incapacitated person may, through a guardian or guardian ad litem, petition for the rescission or revocation of his or her adoption, for the same causes that authorize the deprivation of parental authority. The adopter may, likewise, petition the court for the rescission or revocation of the adoption in any of these cases. A. If the adopted person has attempted against the life of the adopter. B. When the adopted minor has abandoned the home of the adopter, for more than 3 years. C. When by other acts, the adopted person has repudiated the adoption. Section 2. Order to answer. The court in which the petition is filed, shall issue an order requiring the adverse party to answer the petition, within 15 days from receipt of a copy thereof. The order and a copy of the petition, shall be served on the adverse party in such manner as the court may direct. Section 3. Judgment. If upon trial, on the day set therefor, the court finds that the allegations of the petition are true, it shall render judgment ordering the rescission or revocation of the adoption, with or without costs, as justice requires. Section 4. Service of Judgment. A certified copy of the judgment, rendered in accordance with the next preceding section, shall be served upon the civil registrar concerned, within 30 days from rendition thereof, who shall forthwith enter the action taken by the court in the register. Section 5. Time within which to file petition. A minor or other incapacitated person, must file the petition for rescission or revocation of adoption, within the 5 years following his majority, or if he was incompetent at the time of the adoption, within the 5 years following the recovery from such incompetency. The adopter must also file the petition to set aside the adoption, within 5 years from the time the cause or causes giving rise to the rescission or revocation of the same, took place. Rule 101. Proceedings for hospitalization of insane persons. Section 1. Venue, petition for commitment. A petition for the commitment of a person to a hospital, or other place for the insane, may be filed with the court of first instance of the province, where the person alleged to be insane is found. The petition shall be filed by the Director of Health, in all cases where, in his opinion, such commitment is for the public welfare, or for the welfare of said person who, in his judgment, is insane, and such person or the one having charge of him, is opposed to his being taken to a hospital or other place for the insane. Section 2. Order for hearing. If the petition filed, is sufficient in form and substance, the court, by an order reciting the purpose of the petition, shall fix a date for the hearing thereof, and copy of such order, shall be served on the person alleged to be insane, and to the one having charge of him, or on such of his relatives residing in the province or city, as the judge may deem proper. The court shall furthermore order the sheriff to produce the alleged insane person, if possible, on the date of the hearing. Section 3. Hearing and Judgment. Upon satisfactory proof, in open court on the date fixed in the order, that the commitment applied for is for the public welfare, or for the welfare of the insane person, and that his relatives are unable, for any reason, to take proper custody and care of him, the court shall order his commitment to such hospital, or other place for the insane, as may be recommended by the Director of Health. The court shall make proper provisions, for the custody of property or money belonging to the insane, until a guardian be properly appointed. Section 4. Discharge of insane. When, in the opinion of the Director of Health, the person ordered to be committed to a hospital or other place for the insane, is temporarily or permanently cured, or may be released without danger, he may file the proper petition with the court of first instance, which ordered the commitment. Section 5. Assistance of fiscal in the proceeding. It shall be the duty of the provincial fiscal, or in the city of Manila the fiscal of the city, to prepare the petition for the Director of Health, and represent him in court in all proceedings arising under the provisions of this rule. Rule 102. Habeas Corpus. Section 1. To what habeas corpus extends. Except as otherwise expressly provided by law, the writ of habeas corpus shall extend to all cases of illegal confinement or detention, by which any person is deprived of his liberty, or by which the rightful custody of any person is withheld from the person entitled thereto. Section 2. Who may grant the writ? The writ of habeas corpus may be granted by the Supreme Court, or any member thereof, on any day and at any time, or by the Court of Appeals or any member thereof, in the instances authorized by law, and if so granted, it shall be enforceable anywhere in the Philippines, and may be made returnable before the court or any member thereof, or before the court of first instance, or any judge thereof for the hearing and decision on the merits. It may also be granted by a court of first instance, or a judge thereof, on any day and at any time, and returnable before himself, enforceable only within his judicial district. Section 3. Requisites of application therefore. Application for the writ shall be by petition, signed and verified either by the party for whose relief it is intended, or by some person on his behalf, and shall set forth a. That the person in whose behalf the application is made, is imprisoned or restrained of his liberty. b. The officer or name of the person by whom he is so imprisoned or restrained, or, if both are unknown or uncertain, such officer or person may be described by an assumed appellation, and the person who is served with the writ, shall be deemed the person intended. c. The place where he is so imprisoned or restrained, if known. d. A copy of the commitment or cause of detention of such person, if it can be procured without impairing the efficiency of the remedy, or, if the imprisonment or restraint is without any legal authority, such fact shall appear. Section 4. When writ not allowed or discharge authorized. If it appears that the person alleged to be restrained of his liberty, is in the custody of an officer, under process issued by a court or judge, or by virtue of a judgment or order of a court of record, and that the court or judge had jurisdiction to issue the process, render the judgment, or make the order, the writ shall not be allowed, or if the jurisdiction appears after the writ is allowed, the person shall not be discharged by reason of any informality or defect in the process, judgment, or order. Nor shall anything in this rule be held to authorize the discharge of a person charged with or convicted of an offense in the Philippines, or of a person suffering imprisonment, under lawful judgment. Section 5. When the writ must be granted and issued. A court or judge authorized to grant the writ must, when a petition therefore is presented, and it appears that the writ ought to issue, grant the same forthwith, and immediately thereupon, the clerk of the court shall issue the writ under the seal of the court, or in case of emergency, the judge may issue the writ under his own hand, and may depute any officer or person to serve it. Section 6. To whom writ directed, and what to require. In case of imprisonment or restraint by an officer, the writ shall be directed to him, and shall command him, to have the body of the person restrained of his liberty, before the court or judge designated in the writ, at the time and place therein specified. In case of imprisonment or restraint by a person not an officer, the writ shall be directed to an officer, and shall command him to take and have the body of the person restrained of his liberty, before the court or judge designated in the writ, at the time and place therein specified, and to summon the person by whom he is restrained, then and there to appear before said court or judge, to show the cause of the imprisonment or restraint. Section 7. How prisoner designated and writ served. The person to be produced should be designated in the writ by his name, if known, but if his name is not known he may be otherwise described or identified. The writ may be served in any province by the sheriff or other proper officer, or by a person deputed by the court or judge. Service of the writ shall be made by leaving the original with the person to whom it is directed, and preserving a copy on which to make return of service. If that person cannot be found, or has not the prisoner in his custody, then the service shall be made on any other person having or exercising such custody. Section 8. How writ executed and returned. The officer to whom the writ is directed, shall convey the person so imprisoned or restrained and named in the writ, before the judge allowing the writ, or, in case of his absence or disability, before some other judge of the same court, on the day specified in the writ, unless, from sickness or infirmity of the person directed to be produced, such person cannot, without danger, be brought before the court or judge, and the officer shall make due return of the writ, together with the day, and the cause of the caption and restraint of such person, according to the command thereof. Section 9. Defect of form. No writ of habeas corpus can be disobeyed for defect of form, if it sufficiently appears therefrom in whose custody or under whose restraint the party imprisoned or restrained is held, and the court or judge before whom he is to be brought. Section 10. Contents of return. When the person to be produced is imprisoned or restrained by an officer, the person who makes the return, shall state therein, and in other cases, the person in whose custody the prisoner is found shall state, in writing to the court or judge before whom the writ is returnable, plainly and unequivocally. A. Whether he has, or has not the party in his custody or power, or under restraint. B. If he has the party in his custody or power, or under restraint, the authority and the true and whole cause thereof, set forth at large, with a copy of the writ, order, execution, or other process, if any, upon which the party is held. C. If the party is in his custody or power, or is restrained by him, and is not produced, particularly the nature and gravity of the sickness or infirmity of such party by reason of which he cannot, without danger, be brought before the court or judge. D. If he has had the party in his custody or power, or under restraint, and has transferred such custody or restraint to another, particularly to whom, at what time, for what cause, and by what authority such transfer was made. Section 11. Return to be signed and sworn to. The return or statement, shall be signed by the person who makes it, and shall also be sworn to by him, if the prisoner is not produced, and in all other cases unless the return is made and signed by a sworn public officer in his official capacity. Section 12. Hearing on return, adjournments. When the writ is returned before one judge, at a time when the court is in session, he may forthwith adjourn the case into the court, there to be heard and determined. The court or judge before whom the writ is returned or adjourned, must immediately proceed to hear and examine the return, and such other matters as are properly submitted for consideration, unless for good cause shown, the hearing is adjourned, in which event the court or judge, shall make such order for the safekeeping of the person imprisoned or restrained, as the nature of the case requires. If the person imprisoned or restrained is not produced, because of his alleged sickness or infirmity, the court or judge must be satisfied that it is so grave, that such person cannot be produced without danger, before proceeding to hear and dispose of the matter. On the hearing, the court or judge shall disregard matters of form and technicalities, in respect to any warrant or order of commitment of a court, or officer authorized to commit by law. Section 13. When the return evidence, and when only a plea. If it appears that the prisoner is in custody under a warrant of commitment in pursuance of law, the return shall be considered prima facie evidence of the cause of restraint, but if he is restrained of his liberty by any alleged private authority, the return shall be considered only as a plea of the facts therein set forth, and the party claiming the custody must prove such facts. Section 14. When person lawfully imprisoned recommitted, and when let to bail. If it appears that the prisoner was lawfully committed, and is plainly and specifically charged in the warrant of commitment with an offense punishable by death, he shall not be released, discharged, or bailed. If he is lawfully imprisoned or restrained on a charge of having committed an offense not so punishable, he may be recommitted to imprisonment or admitted to bail, in the discretion of the court or judge. If he be admitted to bail, he shall forthwith file a bond in such sum as the court or judge deems reasonable, considering the circumstances of the prisoner and the nature of the offense charged, conditioned for his appearance before the court, where the offense is properly cognizable to abide its order or judgment, and the court or judge shall certify the proceedings, together with the bond, forthwith to the proper court. If such bond is not so filed, the prisoner shall be recommitted to confinement. Section 15. When prisoner discharged if no appeal. When the court or judge has examined into the cause of caption and restraint of the prisoner, and is satisfied that he is unlawfully imprisoned or restrained, he shall forthwith order his discharge from confinement, but such discharge shall not be effective, until a copy of the order has been served on the officer or person detaining the prisoner. If the officer or person detaining the prisoner does not desire to appeal, the prisoner shall be forthwith released. Section 16. Penalty for refusing to issue writ, or for disobeying the same. A clerk of court who refuses to issue the writ, after allowance thereof and demand therefor, or a person to whom a writ is directed, who neglects or refuses to obey or make return of the same according to the command thereof, or makes false return thereof, or who, upon demand, made by or on behalf of the prisoner, refuses to deliver to the person demanding, within 6 hours after the demand therefor, a true copy of the warrant or order of commitment, shall forfeit to the party aggrieved, the sum of 1,000 pesos to be recovered in a proper action, and may also be punished by the court or judge as for contempt. Section 17. Person discharged not to be again imprisoned. A person who is set at liberty upon a writ of habeas corpus, shall not be again imprisoned for the same offense, unless by the lawful order or process of a court having jurisdiction of the cause or offense, and a person who knowingly, contrary to the provisions of this rule, recommits or imprisons, or causes to be committed or imprisoned, for the same offense, or pretended offense, any person so set at liberty, or knowingly aids or assists therein, shall forfeit to the party aggrieved, the sum of 1,000 pesos, to be recovered in a proper action, notwithstanding any colorable pretense or variation in the warrant of commitment. And may also be punished by the court or judge granting writ, as for contempt. Section 18. When prisoner may be removed from one custody to another. A person committed to prison, or in custody of an officer, for any criminal matter, shall not be removed therefrom into the custody of another officer, unless by legal process, or the prisoner be delivered to an inferior officer to carry to jail, or, by order of the proper court or judge, be removed from one place to another within the Philippines for trial, or in case of fire, epidemic, insurrection, or other necessity or public calamity, and a person who, after such commitment, makes, signs, or countersigns any order for such removal contrary to this section, shall forfeit to the party aggrieved, the sum of 1,000 pesos, to be recovered in a proper action. Section 19. Record of writ, fees and costs. The proceedings upon a writ of habeas corpus, shall be recorded by the clerk of the court, and upon the final disposition of such proceedings, the court or judge shall make such order as to costs, as the case requires. The fees of officers and witnesses, shall be included in the costs taxed, but no officer or person, shall have the right to demand payment in advance of any fees to which he is entitled, by virtue of the proceedings. When a person confined under color of proceedings in a criminal case is discharged, the cost shall be taxed against the Republic of the Philippines, and paid out of its treasury. When a person in custody by virtue or under color of proceedings in a civil case is discharged, the cost shall be taxed against him, or against the person who signed the application for the writ, or both, as the court shall direct. Rule 103. Change of name. Section 1. Venue. A person desiring to change his name, shall present the petition to the court of first instance of the province in which he resides, or, in the city of Manila, to the Juvenile and Domestic Relations Court. Section 2. Contents of petition. A petition for change of name, shall be signed and verified by the person desiring his name changed, or some other person on his behalf, and shall set forth a. That the petitioner has been a bona fide resident of the province, where the petition is filed, for at least 3 years prior to the date of such filing. b. The cause, for which the change of the petitioner's name is sought. c. The name asked for. Section 3. Order for hearing. If the petition filed is sufficient in form and substance, the court, by an order reciting the purpose of the petition, shall fix a date and place for the hearing thereof, and shall direct, that a copy of the order be published before the hearing, at least once a week for 3 successive weeks, in some newspaper of general circulation published in the province, as the court shall deem best. The date set for the hearing, shall not be within 30 days prior to an election, nor within 4 months after the last publication of the notice. Section 4. Hearing. Any interested person, may appear at the hearing, and oppose the petition. The Solicitor General or the proper provincial or city fiscal, shall appear on behalf of the Government of the Republic. Section 5. Judgment. Upon satisfactory proof in open court on the date fixed in the order, that such order has been published as directed, and that the allegations of the petition are true, the court shall, if proper and reasonable cause appears for changing the name of the petitioner, adjudge that such name be changed in accordance with the prayer of the petition. Section 6. Service of judgment. Judgments or orders rendered in connection with this rule, shall be furnished the civil registrar of the municipality or city, where the court issuing the same is situated, who shall forthwith enter the same in the civil register. Rule 104. Voluntary dissolution of corporations. Section 1. Where, by whom, and on what showing application made. A petition for dissolution of a corporation, shall be filed in the court of first instance of the province, where the principal office of a corporation is situated. The petition shall be signed by a majority of its board of directors, or other officers having the management of its affairs, verified by its president or secretary, or one of its directors, and shall set forth all claims and demands against it, and that its dissolution was resolved upon by a majority of the members, or, if a stock corporation, by the affirmative vote of the stockholders holding and representing 2/3 of all shares of stock issued or subscribed, at a meeting of its members or stockholders called for that purpose. Section 2. Order thereupon for filing objections. If the petition is sufficient in form and substance, the court, by an order reciting the purpose of the petition, shall fix a date, on or before which objections thereto may be filed by any person, which date shall not be less than 30 nor more than 60 days after the entry of the order. Before such date, a copy of the order, shall be published at least once a week, for 4 successive weeks in some newspaper of general circulation, published in the municipality or city where the principal office of the corporation is situated, or, if there be no such newspaper, then in some newspaper of general circulation in the Philippines, and a similar copy shall be posted for 4 weeks in 3 public places in such municipality or city. Section 3. Hearing, Dissolution, and Disposition of Assets, Receiver. Upon 5 days' notice given, after the date on which the right to file objections, as fixed in the order expired, the court shall proceed to hear the petition, and try any issue made by objections filed, and if no such objection is sufficient, and the material allegations of the petition are true, it shall render judgment, dissolving the corporation, and directing such disposition of its assets as justice requires, and may appoint a receiver, to collect such assets and pay the debts of the corporation. Section 4. What shall constitute record? The petition, orders, proof of publication and posting, objections filed, declaration of dissolution, and any evidence taken, shall constitute the record in the case. Rule 105. Judicial approval of voluntary recognition of minor natural children. Section 1. Venue. Where judicial approval of a voluntary recognition of a minor natural child is required, such child or his parents, shall obtain the same by filing a petition to that effect, with the court of first instance of the province in which the child resides. In the city of Manila, the petition shall be filed in the Juvenile and Domestic Relations Court. Section 2. Contents of petition. The petition for judicial approval of a voluntary recognition of a minor natural child, shall contain the following allegations. A. The jurisdictional facts. B. The names and residences of the parents who acknowledge the child, or of either of them, and their compulsory heirs, and the person or persons with whom the child lives. C. The fact that the recognition made by the parent or parents, took place in a statement before a court of record or in an authentic writing, copy of the statement or writing being attached to the petition. Section 3. Order for hearing. Upon the filing of the petition, the court, by an order reciting the purpose of the same, shall fix the date and place for the hearing thereof, which date shall not be more than 6 months after the entry of the order, and shall, moreover, cause a copy of the order to be served personally or by mail upon the interested parties, and published once a week for 3 consecutive weeks, in a newspaper or newspapers of general circulation in the province. Section 4. Opposition. Any interested party must, within 15 days from service, or from the last date of publication, of the order referred to in the next preceding section, file his opposition to the petition, stating the grounds or reasons therefor. Section 5. Judgment. If, from the evidence presented during the hearing, the court is satisfied that the recognition of the minor natural child was willingly and voluntarily made by the parent or parents concerned, and that the recognition is for the best interest of the child, it shall render judgment granting judicial approval of such recognition. Section 6. Service of judgment upon civil registrar. A copy of the judgment rendered in accordance with the preceding section, shall be served upon the civil registrar, whose duty it shall be to enter the same in the register. Rule 106. Constitution of Family Home. Section 1. Who may constitute? The head of a family, owning a house and the land on which it is situated, may constitute the same into a family home, by filing a verified petition to that effect, with the court of first instance of the province or city where the property is located. In the city of Manila, the petition shall be filed in the Juvenile and Domestic Relations Court. When there is danger, that a person obliged to give support, may lose his or her fortune, because of grave mismanagement, or on account of riotous living, his or her spouse, if any, and a majority of those entitled to be supported by him or by her, may petition the court of first instance for the creation of the family home. Section 2. Contents of petition. The petition shall contain the following particulars. A. Description of the property. B. An estimate of its actual value. C. A statement that the petitioner is actually residing in the premises. D. The encumbrances thereon. E. The names and addresses of all the creditors of petitioner or head of the family, and of all mortgagees and other persons who have an interest in the property. F. The names of all the beneficiaries of the family home. Section 3. Notice and publication. The court shall notify the creditors, mortgagees and all other persons who have an interest in the estate, of the filing of the petition, causing copies thereof to be served upon them, and published once a week for 3 consecutive weeks in a newspaper of general circulation. The petition shall, moreover, be caused to be posted in a conspicuous place, in the parcel of land mentioned therein, and also in a conspicuous place of the municipal building of the municipality or city in which the land is situated, for at least 14 days prior to the day of the hearing. Section 4. Objection and date of hearing. In the notice and publication required in the preceding section, the court shall require the interested parties, to file their objection to the petition, within a period of not less than 30 days from receipt of notice, or from the date of last publication, and shall fix the date and time of the hearing of the petition. Section 5. Order. After hearing, if the court finds that the actual value of the proposed family home does not exceed 20,000 pesos, or 30,000 pesos in chartered cities, and that no third person is prejudiced thereby, or that creditors have been given sufficient security for their credits, the petition shall be approved. Section 6. Registration of order. A certified copy of the order of the court approving the establishment of the family home, shall be furnished the Register of Deeds, who shall record the same in the Registry of Property. Rule 107. Absentees. Section 1. Appointment of representative. When a person disappears from his domicile, his whereabouts being unknown, and without having left an agent to administer his property, or the power conferred upon the agent has expired, any interested party, relative or friend, may petition the court of first instance of the place where the absentee resided before his disappearance, for the appointment of a person, to represent him provisionally in all that may be necessary. In the city of Manila, the petition shall be filed in the Juvenile and Domestic Relations Court. Section 2. Declaration of absence, who may petition. After the lapse of 2 years from his disappearance, and without any news about the absentee, or since the receipt of the last news, or of 5 years in case the absentee has left a person in charge of the administration of his property, the declaration of his absence, and appointment of a trustee or administrator, may be applied for by any of the following. A. The spouse present. B. The heirs instituted in a will, who may present an authentic copy of the same. C. The relatives who would succeed by the law of intestacy. And D. Those who have over the property of the absentee, some right subordinated to the condition of his death. Section 3. Contents of petition. The petition for the appointment of a representative, or for the declaration of absence, and the appointment of a trustee or an administrator, must show the following. A. The jurisdictional facts. B. The names, ages, and residences of the heirs instituted in the will, copy of which shall be presented, and of the relatives who would succeed by the law of intestacy. C. The names and residences of creditors and others, who may have any adverse interest over the property of the absentee. D. The probable value, location and character of the property belonging to the absentee. Section 4. Time of hearing, notice and publication thereof. When a petition for the appointment of a representative, or for the declaration of absence, and the appointment of a trustee or administrator, is filed, the court shall fix a date and place for the hearing thereof, where all concerned may appear to contest the petition. Copies of the notice of the time and place fixed for the hearing, shall be served upon the known heirs, legatees, devisees, creditors and other interested persons, at least 10 days before the day of the hearing, and shall be published once a week for 3 consecutive weeks prior to the time designated for the hearing, in a newspaper of general circulation in the province or city where the absentee resides, as the court shall deem best. Section 5. Opposition. Anyone appearing to contest the petition, shall state in writing his grounds therefor, and served a copy thereof on the petitioner and other interested parties, on or before the date designated for the hearing. Section 6. Proof at hearing, order. At the hearing, compliance with the provisions of Section 4 of this rule must first be shown. Upon satisfactory proof of the allegations in the petition, the court shall issue an order granting the same and appointing the representative, trustee or administrator for the absentee. The judge shall take the necessary measures, to safeguard the rights and interest of the absentee, and shall specify the powers, obligations and remuneration of his representative, trustee or administrator, regulating them by the rules concerning guardians. In case of declaration of absence, the same shall not take effect until 6 months after its publication in a newspaper of general circulation designated by the court, and in the official gazette. Section 7. Who may be appointed? In the appointment of a representative, the spouse present shall be preferred when there is no legal separation. If the absentee left no spouse, or if the spouse present is a minor or otherwise incompetent, any competent person may be appointed by the court. In case of declaration of absence, the trustee or administrator of the absentee's property, shall be appointed in accordance with the preceding paragraph. Section 8. Termination of administration. The trusteeship or administration of the property of the absentee, shall cease upon order of the court in any of the following cases. A. When the absentee appears, personally or by means of an agent. B. When the death of the absentee is proved, and his testate or intestate heirs appear. C. When a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. In these cases, the trustee or administrator shall cease in the performance of his office, and the property shall be placed at the disposal of those who may have a right thereto. Rule 108. Cancellation or correction of entries in the Civil Registry. Section 1. Who may file petition? Any person interested in any act, event, order or decree concerning the civil status of persons, which has been recorded in the Civil Register, may file a verified petition for the cancellation or correction of any entry relating thereto, with the Court of First Instance of the province where the corresponding civil registry is located. Section 2. Entry subject to cancellation or correction. Upon good and valid grounds, the following entries in the Civil Register may be cancelled or corrected. A. Births. B. Marriages. C. Deaths. D. Legal separations. E. Judgments of annulments of marriage. F. Judgments declaring marriages void from the beginning. G. Legitimations. H. Adoptions. I. Acknowledgements of natural children. J. Naturalization. K. Election, loss or recovery of citizenship. L. Civil interdiction. M. Judicial determination of filiation. N. Voluntary emancipation of a minor. And O. Changes of name. Section 3. Parties. When cancellation or correction of an entry in the Civil Register is sought, the Civil Registrar and all persons who have or claim any interest which would be affected thereby, shall be made parties to the proceeding. Section 4. Notice and publication. Upon the filing of the petition, the court shall, by an order, fix the time and place for the hearing of the same, and cause reasonable notice thereof to be given to the persons named in the petition. The court shall also cause the order to be published, once a week for 3 consecutive weeks in a newspaper of general circulation in the province. Section 5. Opposition. The civil registrar, and any person having or claiming any interest under the entry, whose cancellation or correction is sought may, within 15 days from notice of the petition, or from the last date of publication of such notice, file his opposition thereto. Section 6. Expediting proceedings. The court in which the proceeding is brought, may make orders expediting the proceedings, and may also grant preliminary injunction for the preservation of the rights of the parties pending such proceedings. Section 7. Order. After hearing, the court may either dismiss the petition, or issue an order granting the cancellation or correction prayed for. In either case, a certified copy of the judgment shall be served upon the civil registrar concerned, who shall annotate the same in his record. Rule 109. Appeals in Special Proceedings. Section 1. Orders or judgments from which appeals may be taken. An interested person may appeal in special proceedings, from an order or judgment rendered by a court of first instance, or a juvenile and domestic relations court, where such order or judgment a. allows or disallows a will, b. determines who are the lawful heirs of a deceased person, or the distributive share of the estate to which such person is entitled, c. allows or disallows, in whole or in part, any claim against the estate of a deceased person, or any claim presented on behalf of the estate in offset to a claim against it. D. Settles the account of an executor, administrator, trustee or guardian. E. Constitutes, in proceedings relating to the settlement of the estate of a deceased person, or the administration of a trustee or guardian, a final determination in the lower court of the rights of the party appealing, except that no appeal shall be allowed from the appointment of a special administrator. And F. is the final order or judgment rendered in the case, and affects the substantial rights of the person appealing, unless it be an order granting or denying a motion for a new trial or for reconsideration. Section 2. Advance distribution in special proceedings. Notwithstanding a pending controversy or appeal in proceedings to settle the estate of a decedent, the court may, in its discretion, and upon such terms as it may deem proper and just, permit that such part of the estate as may not be affected by the controversy or appeal, be distributed among the heirs or legatees, upon compliance with the conditions set forth in Rule 90 of these rules.